Welcome and thank you for joining Seyfarth's webinar, What Employers Need to Know Regarding Non-Compete Changes in 2023. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Dawn Mertenite. Dawn, you may begin.
Thank you, and good afternoon or good morning, depending on where you are. Thank you for joining us for this year-end webinar. Just a reminder that what we say on this webinar is not legal advice, and we strongly encourage you to reach out to us or a member of our team here at Seyfarth with any specific legal questions you have. Let me introduce the panel for today. Again, my name is Dawn Mertenite, and I'm a partner in the Boston office. I will be handling the Eastern region for today. We also have Marcus Mintz, a partner in our Chicago office. He is going to be handling the Midwestern region. And then we have Dan Hart out of our Atlanta office, who will be handling the Southern region. And finally, Robert Milligan in our LA office, who will be handling the Western region. So before we get started, let's just take a quick look at our agenda. Once we finish this quick overview, we will launch into some federal updates, followed by some regional changes that we have seen in 2023. We will have a separate section for California's new laws because that has been creating a lot of news lately. And then we'll discuss some key takeaways at the end of the webinar. And if we have time, we will take some questions. As Sadie said, if we don't get to your question, feel free to reach out to us. We'll do our best to respond to you. But if we don't have time, we will follow up with you after. So before we move on to the federal update, I just wanted to remind folks that our latest edition of our 50-state desktop reference for non-compete and trade secrets laws is available at our blog at www.tradesecretslaw.com. And in this survey, you will find key information for all 50 states and DC on these topics, including information on notice requirements, wage thresholds, penalties for statutory violations, and more. So without further ado, I will pass this off to Marcus, who will get us started on the federal update.
Terrific. Thanks, Dawn. One of the biggest updates that we've had over the past year was the Federal Trade Commission proposing a rule in January of this year, which would effectively ban all employee non-compete agreements. The ban will also prohibit all de facto non-compete agreements, which has created some ambiguity in terms of what is going to effectively be banned if the rule does in fact go into effect. So there's, while it doesn't explicitly ban non-solicitation or non-disclosure covenants, the de facto language leaves some ambiguity in terms of what in effect will be prohibited. So if there's a covenant that could have the effect of acting as a non-compete, that could be covered by this rule. The rule will also not cover non-competes used in the sale of business, but there's a cap that the FTC is proposing where only owners of 25% or more would be covered. In effect, this would mean that management and many owners would not be able to be tied to non-competes in acquisitions, and we're not quite sure how this will play out in terms of the amount of transactions that could be adversely affected or simply not happen if this rule goes into effect. We've written extensively on this rule and the issues and likely challenges to it. Those articles are available on our website at tradesecretlaw.com. As we've noticed here, the rules received over 27,000 public comments. There was a public forum. Both sides have, both sides being employer protections on one side, such as trade secrets, customer relationships, goodwill, are really at odds with employee mobility and the theory that non-competes restrict wage growth. Both sides have commented extensively, and those comments are all available on the FTC's website. We expect that the proposed rule will be voted on in April of next year. We also expect that if that rule is in fact adopted, it will face an immediate challenge by several groups. And we've also written on our blog about the likely challenges and our expectation that if the rule goes to the Supreme Court, how we expect that to go based on some prior decisions that have been made by this court. And with that, I'll turn to Dan Hart.
Great, thanks, Marcus. Well, not to be undone by the FTC, the National Labor Relations Board has also decided to jump into the non-competes fray this year. And that happened earlier this year on May 30th, when the General Counsel of the NLRB issued a memo in which she set out her view that non-competes in employment agreements and severance agreements generally violate the National Labor Relations Act, or the NLRA, except in rare circumstances. The GC specifically claims that non-competes interfere with workers' rights under Section 7 of the Act. And that's a section of the Act which protects employees' rights to organize, join labor organizations, bargain collectively, and engage in other concerted activities for the purposes of collective bargaining or other mutual aid and protection. So you might ask, what do non-competes have to do with any of that? Well, the GC thinks that non-competes have the effect of interfering with employees exercising their rights under Section 7. If you can go to the next slide, that'd be great. And you might ask, well, why? Why does the GC think that non-competes would have any impact on employees' rights under Section 7? And the theory that she's articulated is that non-competes are overbroad, per se overbroad, not that they can be overbroad, and that employees could think that non-competes deny them the ability to quit or change jobs by cutting off their access to other employment opportunities that they're qualified for based on their experiences, aptitudes, and preferences as to the type and location of work. So presumably, employees who are bound by non-competes think that they're not going to be able to pursue other opportunities, and so therefore they're not going to engage in protected activities. The other part of the argument that the GC's advanced is that the non-competes chill protected activity because employees who perceive that they can't seek new employment may be discouraged from threatening to walk out en masse and join a competitor, even though she concedes that Section 7 doesn't have a right to concertedly resign from employment, but that's the theory. Now, at this point, the memo is just the GC's theory on why, in her view, non-competes and non-solicits violate the NLRA. For this to become adopted by the board as the law of the land, it's going to require the GC, through one or more of the regional directors, to bring unfair labor practice claims asserting this theory, and ultimately for that theory to be adopted by an administrative law judge. And that type of case typically would be then appealed ultimately to the entire board. And then on something like this, in all likelihood, appealed to either the DC circuit or any other circuit. And we've already had now one test case that's been filed. That's a case called Harper Holdings LLC. That's a case recently filed where the regional director of Region 9, which covers a portion of Ohio, filed charges on behalf of 3 individuals at an aesthetics clinic that offered non-surgical cosmetic procedures. And the complaint is interesting in that case in that the regional director alleges that the clinic maintained a number of policies that violate, they believe, the NLRA. And some of those policies are ones that are more clearly within the purview of the NLRB. For example, there's an allegation that there's a confidentiality provision that includes things like salaries, bonuses, and compensation package information in the kind of information that employees can't disclose. But among these supposedly unlawful policies, the complaint also alleges that the employer violated the NLRA by requiring employees to enter into agreements with a 2-year non-compete provision within a 20-mile radius of a clinic, as well as 2-year limitations on customer and employee non-solicitation. Not surprisingly, the employer in that case has filed a motion or partial motion to dismiss and argued that the allegations about the non-compete and non-solicitation covenants should be dismissed because non-competes and non-solicits, in the employer's view, don't violate Section 7 of the NLRA. And the employers argued specifically that non-compete agreements are specifically designed to address issues outside the purview of the National Labor Relations Act. And they've also argued that prior board precedent recognizes that solicitation of employees to work for another company is not a Section 7 protected activity. And so, understandably, they are seeking dismissal of those claims. So far, the ALJ has not ruled on that partial motion to dismiss. But unless the case settles, it's likely to go the distance and probably will ultimately be the subject of appellate review at some time. So we will keep our eyes on that case in the months ahead. Before I move on from the NLRB, I want to highlight one other area that's often overlooked in restricted covenant agreements, and that's non-disclosure covenants. Aside from taking the position that non-competes and non-solicits violate the NLRA, the board has been aggressive in going after companies who have confidentiality or non-disclosure covenants that are written so broadly that employees could think that the provisions are precluding them from sharing information about the terms and conditions of employment. And this is a trend that goes beyond the NLRB. We've seen in the past several months a number of agencies, and particularly the SEC, bring high-profile enforcement actions against companies alleging that they have NDAs that could cause employees to not engage in whistleblowing activity. And so for this reason, it's really a good idea at this time of year to take a look at your existing agreements and assess whether you've got the right kind of carve-outs in there to avoid these kind of arguments from federal and state agencies. Now with this, I'll turn it over to Dawn to talk about wage thresholds.
Thank you. So this is the last piece that we're going to address before we go to the regional updates, although this is regional, as you can see. You may already know that several states, including states that are not listed on this slide, have implemented wage thresholds for non-competes, and in a couple of states, non-solicits as well. What you may not know is that for many of those states, the thresholds change over time. So this slide shows the current threshold for most of those states. I won't go through all of this, but I do want to point out that just about every state has a different way of doing this. So Colorado ties the wage threshold to the amount for highly compensated workers, which is determined by the Colorado Division of Labor Standards and Statistics. Both Maine and Rhode Island tie it to the federal poverty level, which changes over time. Maryland ties its wage threshold to the state minimum wage. Oregon looks at the median family income for a 4-person family. Virginia ties it to average weekly wages for workers in the Commonwealth of Virginia. And Washington adjusts the wage threshold annually according to statute. I do want to point out, I did not add Illinois here. Currently, the thresholds for Illinois are $75,000 for non-competes and $45,000 for non-solicits. We didn't include it in the slide because that number hasn't changed since the law first went into effect, and it's not set to change for a couple of years, but it will, both of those figures will increase in 2027, and then again in 2032 and 2037. Additionally, some states, including Massachusetts, tie the wage threshold to exempt status under the FLSA, and those requirements could change going forward as well. So I just wanted to point that out. So now let's talk about the Eastern region, some updates that we have. We're going to talk first about Connecticut. So in the Northeast region, the main change that has actually become law is Connecticut's new rules regarding non-competes for healthcare workers. Now, prior to this change, non-competes for physicians were limited to a 1-year duration and a 15-mile radius from the primary site of practice, which at the time defaulted to wherever the physician primarily received revenue based on his or her services. Now, the new law requires that any non-compete after October 1st, 2023, whether it's a brand new agreement, an amended agreement, an extended agreement, all of those agreements must be accompanied by a material change in compensation for the physician. The new law also states that the primary site of practice must be mutually defined in the agreement. So it's no longer going to be the default that I just talked about. It needs to be defined in the agreement. You'll see here that there is an exception under this new law. It doesn't apply to practices with fewer than 35 physicians in which the majority owners are physicians. There is an extension of this not only to physicians, but also to advanced practice registered nurses and physician assistants. As you can see here, that's the 1-year duration limit and the 15-mile radius. For the APRNs and PAs, there is no exception for the small group practice, however. So let's move on to, one of the biggest pieces of news that we had this year. Earlier this year, the New York legislature approved a complete non-compete ban that would apply to any worker, employee, or independent contractor. And there would be significant penalties for violation. And again, when I say any worker, employee, or independent contractor, there's no wage threshold there, no exceptions based on salary or title. The penalties are significant. There would be a $4,000 per violation fine. Employers would need to pay for lost compensation and other damages, as well as the employee's attorney's fees and costs if the employer violates the law, which is not in effect yet. Most notably, the proposed ban is ambiguous as to whether there is a carve-out for non-competes in the context of a sale of a business, which is really surprising because typically we do see a carve out there, but that's not in this bill that the legislature approved earlier this year. As I mentioned, it is not law yet. Governor Hochul has not yet signed the bill, and she has until the end of the year to do so. Historically, she has expressed support for limitations on non-competes, but to my knowledge, she has been mum about whether she would support a complete ban. So it remains to be seen if she'll end up signing. I think there was a lot of pushback given not only the lack of exceptions, as I mentioned, but New York is a jurisdiction where obviously there are a lot of businesses, a lot of executives, and a lot of employers, I think, are concerned about this. So keep an eye on our blog. We'll let you know what happens on that front if she signs, if she doesn't sign by the end of the year. Next, I want to mention a few key cases out of this region. I'm going to start in Delaware. Historically, many employers have used Delaware choice of law for their agreements, even if their ties to Delaware are extremely limited. However, since last October, when the Kodiak versus Adams decision was announced, there have been at least 5 decisions out of Delaware suggesting that the courts there are taking a very careful look at covenants that are overbroad. That's even in the sale of a business context, which again, I mentioned, typically we see some of the restrictions a little bit loosened there. Now, reforming overbroad covenants is technically permissible under Delaware law, but judges there are more frequently declining to do so at all, instead striking down the entire non-compete. So where it may have been that historically a judge might say, this nationwide non-compete should really only be limited to, the Mid-Atlantic, a lot of these judges are saying you overreached, and now the result of that is I'm not going to enforce the non-compete for any component of it. So that's what we saw in Kodiak. That's what we saw in Ainsley versus Cantor Fitzgerald, as you see here. And if we move to the next slide, it was also the case for these decisions. Now, the Intertech testing versus Eastman decision I found notable because of the quote that we have on this slide, and that kind of gets to the point that I just mentioned. The court said that it wasn't going to reform the covenant because doing so would save Intertech, a sophisticated party, from its overreach, and that would be inequitable. So again, the court refused to reform the covenant at all and struck down the covenant. Finally, Centurion and Hightower, which are referenced here, similar results. The court determined that the covenants were overbroad, refused to enforce them in any way, but also notable because in these two cases, the Delaware courts refused to uphold the Delaware choice of law, instead applying Illinois and Alabama law respectively. I think that's notable because oftentimes we see if you have a choice of law that might be on shaky grounds, if you actually sue in that jurisdiction, in my experience historically, a lot of times courts would say, well, this is the choice of law. Of course, we're related to this dispute, but the Delaware courts are saying, no, this shouldn't be decided under Delaware law. The parties are in Illinois. The parties are, wherever they are. So that's something to keep an eye on and be mindful of when you're drafting your agreements. Then finally, a few more cases that I wanted to highlight. The Sinosure case, technically it came out in late 2022, but it was late enough in the year that I wanted to highlight it here. The federal court in Boston in that case held that an agreement's Delaware choice of law would not relieve an employer of complying with the Massachusetts requirements for non-competes that bind Massachusetts workers. However, the court did find that stock options could constitute reasonable consideration, and also most notably said that commencement of employment is sufficient consideration under the 2018 Massachusetts Non-Competition Agreement Act, which is something that folks here have been debating for a while. Now, it remains to be seen whether state court judges will agree with that, but at least now we have a federal court judge who has said commencement of employment is sufficient under the MNAA. The last two cases that we have here on this slide, they deal with trade secrets, not non-compete specifically. I did think they were worth a mention since these topics often overlap in litigation. Starting with the Sintel case out of the Second Circuit, the court found that unjust enrichment damages cannot be awarded under the Defend Trade Secrets Act for avoided development costs without actual evidence that the trade secrets value was diminished, which is a significant finding. And then out of the Fourth Circuit, the Synopsys case held that the requirement that information which is alleged to be a trade secret be valuable, that requirement actually means that it must be valuable because it is a secret. So information may be valuable generally, but unless it is valuable because of its secrecy, that is not going to satisfy the definition of a trade secret. So with that, we'll move on to the Southern region and I'll pass it back to Dan.
Great. Thanks, Dawn. Not a whole lot to report in the South compared to some other regions this year, but there are two very important appellate decisions here in Georgia that are worth highlighting. And the first is a case from several months ago called North American Senior Benefits, LLC versus Wimmer. And that's a case where the Georgia Court of Appeals held that an employee non-solicit covenant has to include a geographic restriction. And that's a very significant ruling because never before has Georgia had such a requirement for employee non-solicits. Without going into the weeds too far into that case, as background, the Georgia legislature enacted a restricted covenant statute back in 2011 that had the effect of making restricted covenant agreements easier to enforce. And that came after a 2010 ballot initiative where voters specifically approved that kind of change. The decision relies on an assumption that non-solicited employees fall within the statute, and that's apparently a position that the parties agreed to and didn't challenge. And based on some language in the statute, which has kind of flexible drafting requirements for customer non-solicits, the court held that because the statute doesn't similarly reference employee non-solicits, that employee non-solicits are subject to all the requirements of a true non-compete agreement, including the requirement of having an express geographic restriction. Now, I should note that the employer in that case has filed a cert petition with the Supreme Court of Georgia. The Supreme Court has not yet decided whether it's going to take up that case. It's certainly possible that it will take up the case. It's possible that it will overturn the ruling of the Court of Appeals. Until then, the Wimmer case is binding appellate authority in Georgia. And so in light of that, it's a good time to take a look at agreements with Georgia employees to ensure that they comply with the Wimmer case. And that's particularly the case because of the second decision on the slide. And that's a Supreme Court of Georgia decision called Motorsports of Conyers LLC versus Burback. In that case, the Georgia Supreme Court clarified how Georgia courts should determine whether to enforce a party's foreign choice of law provision in a non-compete agreement. The court held that before a Georgia court can decide to enforce a non-Georgia choice of law provision in a restricted covenant agreement, it first has to determine whether the restricted covenant itself would comply with Georgia law if the court were to construe it under the law of the foreign state. If, as written, the restricted covenant is reasonable under Georgia law, then the court can proceed to adjudicate the case under that foreign law. However, if application of that foreign law would mean that the non-compete is unenforceable under Georgia, then the court is required to ignore that foreign choice of law provision, because following it would violate Georgia's public policy on restricted covenants. Let me highlight as well a couple of legislative developments this year. Next slide, please. A couple of bills that did not succeed so far, but that are worth noting. In Arkansas, there was a bill that died in the House committee, which would have enacted a near total ban on employee non-competes. As I mentioned, that did not survive. It didn't get passed, but it's certainly possible a similar bill will find its way to the legislature again next year. I'll skip over Oklahoma for a minute. Texas similarly had a bill that died in the House without a floor vote that would have banned non-competes for low-wage workers, which was defined as anybody who didn't earn either the federal minimum wage or $15 an hour. Oklahoma is interesting. There's actually a bill pending in the Senate right now, and I'm sure an expert on Oklahoma legislative procedure can correct me if I'm wrong on this, but I understand that Oklahoma's legislative session continues through next year, and so it's possible this bill will get some traction. This bill would enact the Uniform Restrictive Employee Agreement Act. Interestingly, Oklahoma law right now bans non-competes. This bill would have the effect of allowing non-competes to be enforced in certain circumstances, but it also would have the effect of imposing penalties on employers for non-compliance, which is something that doesn't exist right now in Oklahoma law. So these are some issues in these states to take a look at in the months ahead. And with that, I will hand it over to Marcus to talk about the Midwest.
Great, thanks, Dan. By far, the most notable change in the Midwest is that Minnesota joined California, Oklahoma, and a couple other states in the complete ban of non-compete agreements, which is effective on July 1st of this year. Unlike New York, this ban exempts sale of business non-competes, and non-solicit of customers and employee covenants, as well as non-disclosure covenants, are expressly allowed, along with California, Colorado, Washington, and other states. Foreign choice of law and venue provisions are explicitly prohibited by this new statute. So if an employee is in Minnesota, employers will need to use agreements in Minnesota, which applies Minnesota law, specifically identifies the venue in Minnesota, and no non-competes. The second change is in Missouri. which enacted legislation in August of this year and created some presumptions of enforceability with respect to restrictive covenants. Employee non-solicits are presumed to be enforceable if 2 years or less. And these would be restrictive covenants between businesses and owners of businesses. Customer non-solicits will be presumed enforceable if 5 years or less. As well, the courts by the statute were expressly authorized to reform overbroad restraints. And finally, in South Dakota, non-competes are banned for healthcare practitioners for contracts entered into after July 1, 2023. And while healthcare is a discrete industry, we've seen bans like that in South Dakota be enacted throughout the country. So South Dakota joins many other states that have expressly prevented the use of non-competes with healthcare practitioners. Going on to the next slide. There's a couple pending bills in the Midwest region. The first is in Michigan, and this has been pending for a while, and it remains pending. But Michigan would join other states if this bill is adopted, which would prohibit non-competes for low-wage employees. Here, Michigan, their proposed threshold would be earning 138% or less of the federal poverty line. Notice requirements would be in place. And then, like some other jurisdictions, there would be penalties for each violation for employers. And most recently in Wisconsin, there's a bill that would prohibit post-employment non-compete agreements. And this was just introduced in October, just last month. And Wisconsin, under the existing common law, the non-solicits are considered non-competes. This proposed bill is only directed towards non-competes and doesn't address whether non-solicit covenants would also be considered prohibited by this act or would remain viable as under existing law. So there's an open question as to if this bill was even adopted, what it would prevent. Based on our read of the statute, there's likely no effect on the sale of business covenants, and therefore we'd expect that in Wisconsin, as with most states, non-competes would retain viability in the sale of business context. Go on to the next one. In terms of key cases and precedents, there's a recent case out of Illinois that's worth talking about. And Illinois has historically had a bit of a quirk where the state courts of Illinois have required 2 years of employment or some other financial benefit for there to be consideration for use of a non-compete. And recently, Illinois amended the Freedom to Work Act by codifying this body of case law and expressly requiring that employees either be provided 2 years of continued employment or some specific consideration in order for a non-compete or restrictive covenant agreement to be enforceable. In Midwest Lending, which was an appellate opinion that came out earlier this summer, the appellate court considered a challenge to the enforceability of a restrictive covenant where the defendant, former employee, challenged the enforceability of the agreement because he was not employed for at least 2 years and claimed that he received no other consideration. In response, the employer said, well, that's not true. When you were employed, you received a $25,000 sign-on bonus, and that was certainly adequate consideration. The court, however, disagreed And they did so because the sign-on bonus was a separate agreement that didn't relate to the restrictive covenant agreement. And there was no mention in the restrictive covenant agreement that the sign-on bonus was express consideration for entering into the restrictive covenant agreement. Therefore, the court declined to enforce this agreement. And while Midwest Lending Court v. Horton addressed the existing common law, we expect that this authority will be at least persuasive and considered by courts in construing whether or not other sufficient consideration exists other than 2 years of continued employment. And the takeaway from this case is that in the event that employers are opting to use specific consideration in lieu of 2 years of employment, it must be specifically identified in the restrictive covenant agreement itself as to what that consideration is. So that is the big takeaway here in the region, and is a good note where for employers that do business in Illinois and want an immediately enforceable restrictive covenant agreement to review their agreements and make sure that if there's going to be a specific financial benefit provided to its employees, that it go and explicitly identify what that is in the agreement. So, and with that, we'll turn to the West. Pass it over to Robert.
Thanks, Marcus. I'd like to highlight some non-compete changes in the Western region. There were 2 new laws passed in California that are significant. These were signed by the governor in the fall of this year. And we'll get into some of the specifics, but generally, the 2 new laws work together to make it clear that non-compete provisions with employees are unlawful, and that there's a compliance obligation that employers are required to notify current and former employees going back to January 1st of 2022 that such non-compete provisions are void. And additionally, the new law requires prohibits employers for attempting to enforce a contract that is void, regardless of whether the contract was signed and the employment was maintained outside of California. And so we can get into some of the details, but in a nutshell, what this provides is a beacon for out-of-state employees to try to use the laws of California to void or make unlawful a non-compete that they may have signed in a jurisdiction that allows non-competes. Another significant law that came out this year was in Montana, and there was a law banning non-competes for certain medical professions, specifically psychologists and counselors, and that's going to go into effect in Montana at the beginning of the year. As Don noted, in the West, there are 3 jurisdictions that have salary thresholds for non-competes. Those are Oregon, Washington, and Colorado. And so coming into 2024, you'll need to make sure that your agreements comply with those income thresholds. For Washington State, the threshold will be approximately $120,000 and approximately $301,000 for independent contractors. This is often a tedious exercise, but something that HR professionals need to follow closely to make sure that they're complying with the applicable state law. Next slide, please. If 2023 is a precursor of what we expect to see in 2024, we do expect that there's going to be additional legislation introduced in the various Western states. In 2023, there was a bill that attempted to curtail the use of non-competes with health care providers. In Nevada, similar to what Don was explaining in the East, there was also an attempt to ban physician non-competes, and it actually passed in both legislative branches in Nevada, but the governor vetoed that particular legislation. In New Mexico, there was an attempt to ban non-solicitation provisions with physicians, and as well as a attempt to ban out-of-state choice of law and forum clauses. This particular legislation didn't go forward, but we expect that there may be a repeat of that bill in 2024. Hawaii had a quite elaborate statute that was proposed that not only attempted to ban non-competes with many classes of workers in various industries, but really tried to provide some specificity about what a non-compete was, how to define a non-compete, and we expect that that may be introduced in 2024 as well. And then if we were to predict what's to occur in 2024, we'd suspect that California may also attempt to introduce some new non-compete legislations to tidy up what they've done in 2023. And then one significant case that came out this past year came out in Nevada. Now, Nevada had a Supreme Court decision that came out that really put the onus on employers to draft appropriately and draft precisely, and essentially, put the burden on the employer to draft an agreement that was, narrowly tailored to that particular employee. In light of that particular decision, the Nevada legislature passed a statute, which is reflected on the screen, NRS 613.195, that made it clear that the courts in Nevada actually have the ability to blue pencil and modify overly broad non-competes. That was in response to the Supreme Court case. Well, we just had a new Nevada Supreme Court case drop, which is this tough turtle turf case, in which the court had to reconcile the new statute, which gave courts a lot of discretion in whether they're going to reform or blue pencil overly broad non-competes. And the court there was challenged with another aspect of the Nevada non-compete statute, where is basically more pro-employee and indicating that they should not impose a greater restraint than necessary to protect the employer. So in the upshot of this particular decision is a little bit of a tweak in Nevada law, in the sense that it's making clear that the courts in Nevada have the ability to modify overly broad non-competes, but that they're not required to do so, and they should do it when it's possible. So it's giving them some of that discretion back. Their appearance that there may not have been based upon that statute, the NR 613.195. With that, let's turn to the new California non-compete laws. These particular laws were signed by Governor Newsom in the fall of this year. I think it's important to identify what those two new laws are and some of the purposes behind those two new laws. On the screen, you'll see the findings and declarations that are baked into the new California non-compete laws. And this comes from the bill SB 699. And I think it's really important to highlight what these findings and declarations are, because they help you understand what California is trying to accomplish with their new laws. And it may be a surprise to a lot of out-of-state employers and out-of-state employees as far as the breadth and scope of what California is trying to accomplish. They're not only trying to vindicate the rights of California employees, they're trying to vindicate the rights of California employers. And they're trying to make California sort of a beacon on the hill to encourage out-of-state employees to come to California and help California employers, encourage and grow its economy. And so that is some sort of the backdrop behind the statute. And this is actually baked into the particular. This is actually baked into the law, And it's significant because we expect that there will be challenges to this new law, but the folks that drafted this new law were very careful in trying to address particular constitutional challenges that may come up of the new law. Essentially, how is it that you can, by your state's law, try to invalidate, non-competes that were signed in jurisdictions that allow non-competes, and how is it that, I may have had a vested right in a non-compete agreement, but just by moving to California, I can have that agreement, ruled invalid and attempt to get an injunction to prohibit the enforcement of that injunction. That's where these findings and declarations are significant. In the interest of time, I won't read them, but they are, they show you what the backdrop and the policy considerations that are motivating these new laws. Let's get into the first new law, and that's SB 699. It's making clear in this particular new law that the non-compete agreement is going to be void regardless of where and when the contract was signed. And then it's putting a prohibition that the employer or former employer shall not attempt to enforce that non-compete. It doesn't matter where the contract was signed and where the employment was, and whether or not the employment was maintained outside of California. And then it's also making clear that the California employer shall not enter into a contract with an employee or prospective employee that includes such a non-compete covenant, and that if you enter into a non-compete covenant that is void, and that if you attempt to enforce a contract that is void, that's a civil violation. And so it goes on to explain in the statute that it applies to employees, former employees, and prospective employees, and that they have a private action to enforce the chapter for injunctive relief or the recovery of actual damages, or both. And so this, and then lastly, in addition to those remedies, the prevailing employee can get their attorney's fees and costs. And so obviously this, is a situation where if you had an existing employee who, lived and worked in California, and that they had a, non-compete, that this is providing a private action for injunctive relief and also damages, and also the ability to get attorney's fees and costs. The additional significance of this is that this could also apply for that scenario that we discussed. Say you have an executive who is in a jurisdiction such as Delaware that may allow non-competes. By moving to California and working for a California employer, that particular employee can try to avail themselves of this new statute that was recently passed. I think with respect to this particular statute, it's important to understand the proponents of the statute. It was a decidedly pro-employee group of folks who sponsored and supported the statute, but it was also supported by some particular employers, as well as the California Hispanics Chamber of Commerce. Some of the considerations in, going forward with the statute is that they were concerned about the suppression of wages and the exacerbation of racial and gender pay gaps, as well as economic equity. And so some of the same type of language was used at the FTC level, and some of the same law professors that were behind the proposed ban on non-competes at the FTC used these same sort of justifications to support the bill. The significance, though, is that as I indicated in the findings and purpose, that has now become the law in California. That findings and purposes are now codified, and that's something that hasn't been codified at the federal level. It's just as part of the proposed rule. If we go to the next slide about the legislative history, it's clear, and one thing that employers doing business in California need to understand is that this particular statute is to protect California employees as well as California employers. And so that's why there's this breadth of scope of trying to entice out-of-state employees to come work for California employers, regardless of whether they may have a non-compete. Now let's get into the next slide. Let's get into the second law that is, works hand in hand with the first law, and this is where you find the notification requirement. But before we get to the notification requirement, the particular second law, it amends 16600. And so if you're familiar with 16600, there's the preliminary provision that indicates that certain contracts are void. They added additional language, B1, B2, and C, to make it clear that this particular section shall be read broadly. And there's a seminal case, Edwards versus Arthur Anderson, that deals with non-competes. That particular case dealt with a customer non-solicitation provision. And in the new law, they're making it clear that the section should be read broadly to void any non-compete agreement and any non-compete clause in an employment contract. Unfortunately, and part of the consternation that employers are facing is there is no definition of what is considered a non-compete agreement or a non-compete clause in the new statute. And so that's going to be a litigated issue as far as the breadth and scope of what is considered a non-compete. And another key point to highlight on this addition to the statute is that it applies not just to contracts between the employer and the employee, but this section C indicates that it applies to even if the person being restrained is not a party to the contract. And so that could apply in the case of business-to-business type of arrangements. Remains to be seen how broadly it be construed. Next slide, please. Now, this is the last section of the new law, and this provides for the notification requirement that employers have as a result of the passage of this new law. The first portion of the law reiterates that it's unlawful to include a non-compete clause in an employment contract or to require an employee to enter a non-compete agreement. That does not satisfy an exception to the chapter, and there's very limited exceptions that have been codified over the years and through the case law. And so as far as the notification requirements, for current employees and former employees who were employed after January 1st of 2022, the employer is to notify by February 14th, Valentine's Day 2024, that the non-compete clause or non-compete agreement is void. So that's a affirmative obligation of the employer in California to provide that notice to current employees and former employees who satisfy the definition. And now employers are grasping at, well, what is a non-compete clause and non-compete agreement? And so there's a considerable amount of debate as far as how broad that should be interpreted, whether that should be interpreted to include customer non-solicitation provisions, employee non-solicitation provisions, forfeiture arrangements, overly broad non-disclosure agreements, and invention assignment agreements that are overly broad. And so there's going to be a considerable amount of probably litigation about what this particular clause means. As far as how do you deliver the notice, it needs to be provided to the last known address and the email address of the employee or former employee. And that notification needs to occur by Valentine's Day of next year. Now, if you violate this particular section by not providing the notice, that is going to constitute unfair competition under California's Business and Professions Code 17200. Next slide, please. I know in the interest of time, so that we can get into a little Q&A and a little practical application, I did want to highlight briefly the legislative history. the legislative history is very significant because it tells you what the intent, it tells you who was behind this particular litigation or this legislation, and how likely they are to push the scope and breadth of the statute in challenges in court. So next slide, please. So in sum, on slide 37, it marries together what SB 699 and AB 1076 do as a matter of law as far as the change to California law. And that's probably your best summary of how this changes the existing law in California and what the compliance requirements are by the beginning of the new year. Now, some of the unanswered questions is how does this change in California law interact with Labor Code Section 925? Labor Code Section 925 was a statute that indicated that you couldn't, in agreements with employees as a condition of employment, prevent them, require them to litigate claims outside of California or deprive them the substantive protection of California law. But there were exceptions to that particular Labor Code Section 925, particularly if the employee was represented by legal counsel or the agreement was not a condition of employment. I think based upon the legislative history, the drafters' likely intent was to circumvent Labor Code 925 exceptions, but that's going to be played out in the courts as whether 925 exceptions are still viable ways to use restrictive covenants with employees. It's also not clear from the statute of how this is going to affect judgments that are secured outside of California. In other words, if you were to get an injunction or damages for a jurisdiction that allows a non-compete, such as New York, Florida, and whether the California court will honor that, there's likely going to be constitutional challenges to these two new laws under the Interstate Commerce Clause and potentially the Contracts Clause. With that, I'll turn it over to, I believe, Dawn about what do these changes mean for employers?
So we only have a few minutes left. Marcus, do you want to quickly read the CLE code? Because I know a couple people have asked about that before we get further.
Sure thing. Our CLE code for today's presentation is SS as in Seyfarth Shaw 6588. Once again, that is SS 6588.
Thank you. And so as Robert suggested, with the latest California laws, there's no one size fits all solution here. You should be looking at which employees are impacted, take a look at the covenants, determine who needs to get individualized notice and what that notice is going to look like, consider amending or updating agreements, reaching out to counsel to determine what this means for out-of-state employees. I saw a question about that, and frankly, that's undecided at this point. So we're still grappling with the impact of that, and so on and so forth. Since we only have a couple minutes left, let's skip forward to the next slide where I think we talk about key takeaways. And I think, Dan, you were going to quickly run through this.
Great, thanks, Dawn. Yeah, very quickly, in the interest of time, I want to leave you with three practical takeaways here for what this means for your business. First, it might go without saying, but this is a time to review and, as necessary, enhance your existing agreements. There's been a lot of change. There's a lot more change on the horizon. Really makes sense to do a comprehensive review of the templates that you have. If they haven't been updated in a couple of years, they are almost certainly out of date. And it's a good idea to look at what needs to be tweaked in your existing agreements. Second is, as you're reviewing your agreements, really customize the restrictions for maximum protection, based on what kind of employees are being bound by these agreements. It's no longer the case, if it ever was, that one size fits all. So you might want to have non-solicits specifically for your sales reps, maybe different covenants for folks in the C-suite, different covenants still for people in R&D. And that's an exercise that you ought to engage with outside counsel and your in-house legal team and HR. And finally, as you're updating your agreements, consider the state-specific nuances that are now required. I mean, there's so many different variations in the law in various states. There are carve-outs required in some states. These are considerations as you're drafting how you're going to make allowances for sometimes completely contradictory laws in different states as you're trying to implement these agreements on a 50-state basis. Let me turn it over to the entire panel. Any other key takeaways that you'd like to highlight as we're wrapping up today?
The only thing I'll say is that, unfortunately, we don't have time to answer these questions. We had a lot of really great questions, especially about California. Again, this just underscores how important it is to have counsel that you trust that can work with you. Again, a lot of these rules are not as clear as in all cases you do X or you never do Y. It depends on your business. It depends on the risk analysis. So we encourage you to reach out to one of us or another member of our team so that you can get some specific advice. So we apologize that we didn't have time to take the questions. We'll reach out to you after the webinar and hopefully get you answers. But again, feel free to reach out to us. You can find our information on our bios. Thank you so much and have a great afternoon.
Thank you, everybody.